The subject this evening is unfair dismissal in Halacha, and it's the 11th of November 2020, coming up to Parshas Chayei Sarah. Now, is there a concept of unfair dismissal in Halacha? The answer is there is. A person's employment is protected to a certain extent by Halacha. Now, where did it come from, and what exactly is that concept? We discussed this a bit last week, but we're going over this as a starting point for this week. And if I remember correctly, Simon, where we left off last week was, given that there is a concept of having dismissed someone unfairly, would you have to pay to compensate him? The fact that you weren't allowed to do it doesn't necessarily mean you have to pay. Two issues. I mean, if you were allowed to do it, presumably you wouldn't have to pay. But the fact that you don't have to do it, the fact that you're not allowed to, if you were allowed to do it, presumably you wouldn't have to pay. But the fact that you're not allowed to do it doesn't necessarily mean you have to pay, because whether you're allowed to do something and whether you have to pay for it, there's a certain level of distinction between them. So first, the actual idea, and under which circumstances is a person's work protected, and what is the nature of an issa there may be to dismiss him from that. So in summary, one could perhaps say there are four things to bear in mind. I don't know whether to call it four distinct approaches, four tracks. You'll see what I mean as I go through it. As I mentioned last time, Rav Moshe Feinstein mentions in the Tshuva that when you employ someone for a particular need, so for example, you have a factory, and because of whatever the factory does, you have a need to employ someone to perform a certain task, to oil the conveyor belt, to put a certain thing into the machine, to put two bits of things, whatever it may be, but there's a certain role to play, and that role definitely needs to get done because of the infrastructure, because of the setup that you have. But Moshe says, if you say to someone, could you work for me? I'd like you to perform this role. Here you are, here's the job. You didn't specify you're only giving it to him for a week or a month or a year, limited contract. You just said, please take the job. But Moshe said it's implicit in the contract, the arrangement that you formed between the two of you as you gave him the job, that you are giving him entitlement to that job. You're giving him the job so long as you need someone to perform that role. If that's the case, you can't tell him to leave unless for some reason it's impossible to have him on that job. That could happen if the factory burnt down, so the business no longer exists, or the factory had to close for a different reason maybe. Or it could happen if it became clear that he was profoundly unsuited for the job, or even if generally suited, but misbehaved, there was misconduct on the job that made it completely untenable to have him on the job. But so long as it's reasonable and viable to have him on the job, you have to have him. Therefore, you're not allowed to dismiss him. So that's how Rav Moshe learned. The Chazon Ish disagrees. I mean, the Chazon Ish doesn't bring Rav Moshe. He came before him. It could be some of what Rav Moshe wrote, by the way, was when the Chazon Ish was still alive, but generally, I don't think he quotes him anywhere. And the Chazon Ish says that it can't be that, in other words, why the Chazon Ish talks about it, like I say, it's not quoting Rav Moshe. The Chazon Ish is considering when you employ a poel, when you take on a poel, when you employ an employee, how long are you taking him for? And the Chazon Ish is cognizant of the fact that no clear, specific provision exists in halacha, and it's obviously perfectly plausible that a person can employ someone and not make a specific arrangement for a certain amount of time. So we need to know, according to halacha, how long it will take effect for. The Chazon Ish's principle is that it doesn't stand to reason that a person should be implicitly understood as having made an open-ended commitment to someone. Therefore, he disagrees with Rav Moshe's idea that the employment is permanent, as long as you need that job. The person wouldn't want to tie himself to someone else forever. So he says the employment is whatever length of time is the norm within that employment. If the length of time before you would renew a contract is a week or a month or a year, there'd be a certain unit of time that you'd expect to be associated with that particular work. So that's the approach of the Chazon Ish. So you're committed in that time. If that time was a month, then you couldn't lay him off within that month, but you could at the end of that month. By the way, I wonder if there's an interesting quirk according to the Chazon Ish. If according to the Chazon Ish, the norm, we look at the norm, and the norm is if you take someone to do job X and Y, you would never sack them within a month, or you would never sack them within a year. If that's the case, I wonder whether you could make an argument that in Holocho, that employment would still continue even if you didn't need the job anymore. But according to Rav Moshe, the whole definition of the employment is so long as you need that job done. So the moment it becomes unsuitable, then there's that lapses, and that breaks the contract. You don't need to have the contract going beyond that. Good evening, Joe. We're just recapping on a few things from last week.
Okay, yeah, sorry, I'm a bit late.
Yes, okay. We've said that we established there is a concept of unfair dismissal in Halacha, and there are four, what I might loosely call four approaches. I mentioned Rav Moshe Feinstein, as we said last time. But fundamentally, if you give someone a job, then that job remains entitled to do that job so long as the job exists, so long as you have that need. The Chazon Ish says it's more linked to an amount of time which is standard for that particular job. You'd have made the commitment for a week or a month or a year or whatever would be the norm for that job. Now, all agree, those are the two halachic sources that I'm quoting, but all agree that the expression that the Gemara uses, Hakol K'minhag HaMedina, everything goes according to Minhag HaMedina, the local custom and practice, all agree that is determinative in halacha, because that's what people are doing. That defines the norm, and that creates the expectation. So in an arrangement like an employment, which is ultimately a contract, and as I keep saying when I say contract, I don't mean a written contract. I mean the concept that it's a two-way transaction. When you pay money in a shop, then at a certain point, the kinyan takes effect, or the legal obligations take effect in English law, in whatever system of law you're using, and a reciprocal obligation is created on the other side. That is what's called a contract. So by the same token, in employment, a contract is created, an obligation, liability on both sides, which are reciprocal and which are contingent upon one another. So Minhag HaMedina very often in Chosh Mishpat defines that, because it's a window into what people's expectations would be. People would expect something to go in the way that everything else goes. Consequently, to understand a question like unfair dismissal in halacha, you have to know what the law says, because the law may well be the minhag. So in this context, it's good to know the following, that Simon's entered the waiting room. You're coming in on a second device, Simon. That's very interesting, because the other picture of you has you with. So according to UK law, the basic rule is like this. There's an interesting quirk according to UK law, which you probably know about. It's very, very well known. that there's a sort of buffer period of 2 years in UK practice. That I suppose the understanding of it is straightforward, that it's fair enough to want to test out how effective, how good an employee is for a job for 2 years, and to be able to say within that 2 years, look, you're not suitable, let's go our own separate ways. But at the same time, once somebody's been working for you for 2 years, people need permanence, they need reliability in their work. The English culture, seemingly, or the UK culture, is very, very sympathetic to that. But once an employee has worked for 2 years, the minig is then, as I say, the UK law, and therefore the minig is that one would not be able to dismiss them from their job unless there was a specific, sufficiently valid reason. And the reasons have to be very strong. It has to be that the employment becomes untenable either because of not capable of performing, or there's misconduct which is serious enough to jeopardize the whole employment, or it becomes redundant, there becomes no need, and so on. One or two other things. No, 1 second. One of the other things is some other substantial reason, which really is a catch-all in case for something else that makes employment untenable, but is not included in the other 4. I mentioned 3 of the other 4. I don't remember what the 4th is. I don't know if any of you know. These are things you're familiar with? I don't remember what the 4th is, but it's along the same lines. Yeah, maybe it's constructive dismissal. No, one more thing. Constructive dismissal is what you're not allowed to do. When are you allowed to? You're allowed to, if there's a poor performance, poor misconduct, redundancy, some other substantial reason, or a 5th. Readily obtainable on Google, if you're in the mood, Michael. You'll see what the 5th reason is. But I think if you think about it, aside from the issue of there being a distinction between pre 2 years and after 2 years, this is very similar, maybe identical to Moshe's criteria, because the whole idea is that the employment is untenable. So long as the employment is in any way tenable, you have to carry it on. What's interesting, and I'm not sure how Holocho would view this, because this is a detail. Suppose an employee can't work for quite an extended amount of time. Now we know the concept of maternity leave, so it's quite usual for long-term. Have you found it, Michael?
Yes, it's a statutory illegality or breach of statutory restriction, basically meaning that, for example, a lorry driver who in all respects is competent in his work, but loses his driving license for a particular reason not related to his work, then he would be in breach of a statutory restriction, which would render him unfit to continue in that employment. So that's the 5th category.
Well, okay, so I would say that I think it's not obvious that Holocho would support that, because in practical terms, if he doesn't have a driving license, you can't get him to do the work, because it won't work. Eventually, the police will pick him up and put him in jail. So it's not safe. However, what would happen if there was does that include some illegality that he's done?
Yeah, some statutory, in other words, a reason that is an exogenous reason, a reason that is not related to the performance of his work or contractual arrangement that he has with his employer or any bilateral nature. It's something outside of that, in which there is a statutory reason why he is rendered incapable of performing his duties.
In the country, for example, he's not supposed to be in the country.
That would fit into that category. It's very rarely used, but that would clearly be a reason that an employer could give. They still have to follow the procedures for dismissal, but they would be able to use those as grounds for dismissal. That's my understanding.
I think my mind is just racing, because I'm thinking how that would coalesce with Holocho. It would seem to me off the top of my head that if you could, this is probably this is probably only theoretical. If it were the case that the worker was working illegally, but Lemaisa, he was doing his job and it wasn't doing you, the employer, any harm, I don't see what halachic grounds you'd have to lay him off. Unless you'd say that you can't, that it's not right for you to, even halachically, it's not right for you to allow his illegality to continue. I don't know, but I see in practical terms.
So if the authorities intervene, then you'd have to, no? As the employer, the authorities told you were illegal, employing this person illegally,
and you're getting into trouble. Well, that's what happened to Mr. Rabashkin, isn't it?
Yeah, but the authorities wouldn't have to tell you anything. I mean, there's a statutory framework, and if by employing him he is in breach of statutory regulations, then that's it. Then the employer has a right to terminate the employment, and it's a specific example of that section. Is the example that the rabbi's just given, which is the right to work in the jurisdiction in which the employment is supposed to take place in the UK, for example. Definitely, it's not if the immigration authorities catch up with him and physically march him out of the building. Just his eligibility to work in the UK is impaired, and therefore his employment can be terminated because of that.
I had a very interesting case. Well, I'm mentioning now maternity leave because I find it's a very interesting thing that it's completely normal, and maternity being the classic model for this, a classic case in point, perfectly normal for a person to have to take many months off for maternity and yet to retain their job.
Not in America, it's not. Only in this country and in Europe, the rules are much more generous to women who have given birth. In America, there are no comparable arrangements, and I don't think there's even a comparable arrangement of paternity. The arrangements. I mean, there is a notion.
I was actually going to say something about American law.
Paternity leave. I mean,
I've done my homework, but I don't know about this particular detail. But what I was saying was that Rav Moshe's criteria is that person can't do the job. Now, if a person can't do a job for a week, so that doesn't mean they can't do the job permanently. They can come back after the week. You may be able to lower their pay or cut their pay for that week because you need to take temporary staff, but that's not a reason to lay them off permanently. I think that's clear. But the question is, what if that becomes extended longer and longer and longer and longer and longer? And an HR specialist told me of a case that she dealt with where which was such a case, something pretty chronic, and it was going on and on and on and on and on. And at a certain point, it just became untenable to hold the employment, and they did terminate the employment, but on the basis of some other substantial reason. The fifth catch-all clause. It was recognized that there comes a point at which the temporary leave is so extended that it's not reasonable to expect the employer to continue the employment. But in the way it's practiced in this country, it's certainly quite generous towards the employee, because it certainly can last for many months. And I was wondering what Holocho would say about it. Holocho does mention, just as an example, a case of Holocho person with a comparison. There's a comparison to an Eved Ivri scenario, and Eved Ivri is an Eved for 7 years, and it talks about being ill for 3 years and being able to work for 3 years, and that suggests that Holocho is similarly generous. But I don't know if I can prove that. But what I will tell you, the very interesting case study. And this is a case that I've had to deal with. I've got to get this finished. It's been schlepping on for some time, but I've reached a conclusion. There was a young lady who was working as a secretary for someone. And because of her childcare arrangements, she had difficult personal arrangements with a single mother and so on. So she, perhaps I'll change one or two details of the case. She obviously had the pressure. Without a husband available, she had great pressure of childcare. And when the pandemic broke out and any sort of schooling or nursery arrangements stopped, she told her boss, I simply can't work like this. Please, can you put me on furlough? And the whole country had come to a lockdown, and he put her on furlough, and that was fine. But after a few weeks, when things eased up and they were trying to reopen the economy, the boss wanted to get back to work and asked her to come back to work. At which point she said, I can't work because my children have no school framework. I've got to be their school framework. And I can't even work, some discussion about working from home. She said, I can't do that. I've got to be present. My children need me. And she felt and insisted that she was unable to really return to that job for the full 6 months, 2 periods of furlough. And the employers felt this is just completely unreasonable. And at a certain point, after a bit of a run and a bit of give and take and exchange of fire in emails and so on, he said, I'm sorry, you're dismissed. And she said that was unfair dismissal. She asked for compensation. And I think my conclusion was that she's right, because the attitude based on certainly based on UK minhag, would be that she was willing to come back to work in October, soon, or September, October, whenever it was, as soon as the schools would reopen. But she'd asked for this long absence. There's emerged somewhat of a consensus to be sympathetic to people with COVID situations, even though one could say there might be other mothers who would say, look, you can still just get on, it's unusual circumstances, you get on with your work, put a video on for them, you'll manage, find someone else to look after them. She said that was not possible for her, and that was and I felt that was credible. I wondered how would Holocho look at it? What would Holocho have the same sentiment? And I found various sources which talk about a worker. One source talked about a worker being ill or his family members being ill, implying that Holocho acknowledges the illness of a family, something that's going to make a person unable to work, the needs of the family. And in a completely different place, in Hilchos Talmud Torah, that everybody needs to learn Torah. Even Baal Isha Banim, even a person who has a wife and children has to learn Torah. I think it says something like even someone who's unwell, someone who's weak, and even someone who has a wife and children, implying that it's well understood that wife and children keep you very, very, very busy. And I thought that was sufficient to defend her case. And that's what comes out in UK law. Interestingly, in American law, there's no such concept. Fundamentally, there's no such concept. In other words, as I'm led to understand, the vast majority, perhaps 99% of employment is set up to be what's called at-will employment, which means the basic arrangement is that either the employer or the employee can terminate the employment whenever they want. Now, what's interesting is the big gap between what happens in theory and in practice, or maybe said slightly differently, what the basic concept is and what actually happens in practice, and the reason for that. The basic concept is you can dismiss someone for any reason you want, or actually even for no reason, because it's at will. You don't want that person working. But there's an exception which makes all the difference. The exception is you can't dismiss them for an illegal reason. So you can dismiss them for any reason which is simply your whim, or for no reason at all. But certain reasons are disallowed because they're illegal, discrimination and so on. So in practice, if a person says, you know, I don't want you to work for me anymore, please go. What reason? No reason. In practice, if the employee would then take the employer to court demanding compensation, demanding that he or she was laid off for whatever reason they think may be the case, and they might consider it illegal, they might consider it discrimination. If the employer would say as his defense, actually it was for no reason at all, the court would probe that, because people who are running businesses normally don't decide to lay off their workers for absolutely no reason. And therefore one is well advised to completely steer away from that. You have to, well, first of all, you have to have a reason if you don't want to put yourself open to risk, and make sure that the reason is properly communicated and a certain process is followed, makes the reason crystal clear and adequate and not illegal, and then the employer is protected. But it is interesting that there is that difference. And although in many cases the final outcome would be similar in UK and the USA, and I haven't checked the following point, I suspect in the point that I'm about to say, when there's extended absence, I would guess that would be sufficient reason. As you mentioned, Michael, about maternity and so on. Why should an employer want the inconvenience of an employee being off for many months? Why should he accept that? Why should that be considered why should that not be regarded as an understandable reason on his part? In the UK, where a particular threshold has to be reached, has to be untenable, then that doesn't apply. They'll get temporary staff off, get temporary staff to fill in for the next 6 or 9 months. But in America, that's probably not the case. In any event, so we've got sort of 4 tracks. The Measure of Motion, the Chazanish, and English law and American law. But at the end of the day, there are many cases in which a person's, the basic idea is that there has to be, in many cases, good reason to lay someone off. Now, so that establishes that there are cases that you may not dismiss a person from employment. Now, the next question is, if you did, are you chayav to pay? So I think the starting point for a halachic discussion of this is that with basic halachic knowledge, I think it would be quite natural to suggest that one's not chayav to pay, because we know that the Gemara and a well-known halachic principle that halacha looks primarily at direct actions that a person does, in terms of fulfillment of mitzvahs, in terms of averos. Where something is caused indirectly, that's called a groma, and that isn't the direct action of a person. Now, surely if you dismiss someone, they might have a complaint that they've now lost their source of income. But what's happened is you said, right, I don't want you coming back tomorrow. Here's your paycheck to the end of today, or here's your paycheck to the end of next month, notice period, or whatever it may be. Beyond that, please don't come for work, and then I'm not going to pay you. Now, have I caused direct damage? I've caused her not to be able to come to work, and therefore I will not pay her. It doesn't sound very direct to me. So should we not then say groma b'nizakin potter? I don't remember what the classic example in Gemara is of groma b'nizakin. What do I remember? There's a Mishnah in the 5th parak of a Kam, I believe, which is a koines tzoin ledir. If you left a don't remember the exact case. I think you left you had perhaps the case is you had you were looking after someone's animals and you had them in a pen and you left the door of the pen open and the animal wanders out, or ganovim come in and steal it. Don't think you'd be chayav to pay, because what you did was very indirect. It was just a groma. Suppose you are in somebody's house and there is a window or a skylight, and immediately by that window, underneath that skylight, there is lying on a table a a valuable painting. And let's just, for the sake of to make this more clear cut, let's assume that when you opened the window, the sky was completely clear. You opened the window, then a few hours later, the skies started graying up. Rain clouds came. There was a storm. Rain fell in and damaged that painting. Now, unquestionably, that painting got damaged because of your action. Had you not done that action, it wouldn't have got broken. I mean, we can construct a scenario. You were there by yourself. No one else was in the house. No one else could have. It's not even as if you could say that somebody should have closed it. No, there was no way no one else was present. Yeah, what you did was just very indirect. You opened the skylight. The sky was clear at the time. A while later, clouds came along, and a while later, it started raining. You didn't do that damage. So the concept of groma b'nizakin potter. Should it not be considered groma if you fire someone from a job, you cause someone to lose their employment? You've indirectly caused at a later date they won't be able to receive further panosa from this work. Now, there are basically 4 answers to this. In other words, there are four halachic principles according to which you might have to pay, despite the fact that on the surface it seems to be a groma. Now, the 4 answers.
Can I just stop you there for a minute, just to clarify something? Because you gave 2 examples, but they don't seem to be analogous. The first one, the first one with the, leaving the thing open and then the clouds coming along, which may or may not have happened. There was no certainty, but obviously if you fire somebody, there is a certainty that they won't be due their wages.
Right.
So I don't see what one's got to do with the other.
Right, but it's still quite indirect.
Well, I don't think it is indirect with the way it's firing someone. It's the obvious consequence is that they won't be paid because they won't have the job anymore. It's like night follows day. In our religion,
what you're coming on to really is the Gemara says in a few places, Rabbi Doniel Grunewald. The mayor used to judge a din called garmi. Now, garmi is obviously a very similar word to groma. I don't know what exactly is the grammatical distinction between garmi and groma, but it's a different turn of phrase. And have you come across this in the Gemara? Dina de garmi. There's a classic example. Somebody has a shtar choiv, and you burn it. Now, he was going to use that shtar choiv to collect the £5,000 debt. Now, you burn that shtar choiv, he can no longer support that debt. So if the person who owed him the money, let's say it's a borrower, denies that debt, he'll have no way to collect the debt. He'll have no way to prove it. The mayor said, you've caused him that loss, you have to pay. The Gemara says, "Rabbi Doniel de Grunewald." Now, the question is, it seems to be indirect. We say groma b'nizakin potter. I say the question, but I think Joe will be thinking he's already answered the question. And according to the general understanding, you have answered the question. Just want to bring a bit more clarity. So I'm bringing it out initially as a question. The general understanding is, as your understanding, that there are 2 levels of cause. It's still called garmi, and there's still a machlokes about it in the Gemara because it's not a direct action of damage. It is somewhat indirect, but it's more sharply direct. It's more, I don't know how to call it, sharply causative. It's more direct than a groma, and there are 2 levels.
Maybe you're saying less indirect.
Pardon?
Or maybe you're saying less indirect.
Less indirect. Okay, that's the thing. That seems to sort of capture it better for some reason. I'm not sure why. But the matter with, I'll give you a little glimpse into the world of imagining yeshiva learning the sugyas of groma and garmi. It's very hard to pinpoint the difference. And I think the difference is not well understood and maybe not completely clear. And I think upon analysis, which I've not done in depth, but I have heard that even upon quite close analysis of splitting hairs and careful reading of every jot and tittle of the words of the Rishonim on the Sugyas, one does not come up with what emerges is that there are different approaches and different ways of understanding the exact difference between Grom and Garmi. It's not something that's perfectly clear, but I think there is, I think we cut through that in terms of practical Hanhaga based in, it is, I believe, an accepted psak that we do paskin Garmi, and we accept a certain definition, which the phrase you hear from Dayanim, I think it comes from a Shach in Smishin Pevov, there has to be miyad, there has to be biyad, and there has to be bari hazeka. Now miyad means there has to be immediate. Now what has to be immediate? And this troubled me, it seemed vague, because take the classic example of a Seif Shtar Choiv Shel Chaveroi. You have a Shtar Choiv, you don't really care as such about the Shtar Choiv. What you really care about is that you should get the money, you should get paid. Now that lack of payment is not happening now, is it? That lack of payment is gonna come when you try to claim the debt. That is going to come when you try to claim the debt. Sorry. So, as I say, miyad, biyad, bari hazeka. Miyad means immediate. Biyad is it's done by the hand. So I guess it's not that you. We're talking about a loan document, a shtar choiv. So let's suppose you had you took someone's document and you put it somewhere precarious where eventually it fell down. So that itself was done by an indirect action, and it wouldn't be biyad. And it has to be bari hazeka. There has to be clear that the damage will come, as you said. If you leave someone's skylight open for a certain period of time, the clouds may come, clouds may or may not come. I guess that's not Garmi. So I think you've pinpointed at least one aspect of the distinction between Grom and Garmi. And as I said, in the Sugyas, it's hard to learn. I've heard it said that maybe according to Rashi, there's actually no difference. Maybe it's just, sometimes the Aramaic of the Gemara seems to be slightly inconsistent, and slight variations of words. Garmi, Groma all means you cause. Halacha may be completely different according to Rashi, but the general normative psak is that there is a concept of Garmi when it's more direct than Groma. And again, it may be hard to pinpoint exactly where it applies and where it doesn't, but we cut through that to at least to certain practical cases, because there is, and I think this comes from the Tosfos, but it's certainly the halacha itself is certainly mafurish in Shulchan Aruch. Suppose you have a field. This is now bringing the concept of Garmi to an employment scenario. So this is taking rather long, but let's just refocus. What I'm saying now is, if you dismiss someone unfairly, would you be chayav to pay? Ostensibly, it would be groma, but I'm answering, actually, there are 4 halachic avenues to explore, according to which the outcome may be that, yes, you do have to pay. Avenue number 1 is that it's Garmi as opposed to Groman. Garmi you're chayav to pay. And I'm telling you that the classic example of Garmi as follows. Let's suppose you have a field and you need workers to come in to work your land. And the day before they're due to come, and I'll just throw in a point which is relevant, they haven't started the work yet, they haven't started traveling, they haven't started preparing for the work, they definitely haven't started doing anything yet. But it is quite late. You arranged this work 3 weeks ago or a month ago, and you're only calling them a day before, and you say, please don't come in. I've decided I don't want to work that field. Why? It's my own decision. I simply decided that. Now, if the workers could then get similar work elsewhere, and that's a matter of local norms, of market forces, there's work available, then let them get work elsewhere. But if not, then you've caused them that loss, and you have to pay. And that's classed as direct enough to be dina de garmi. So we have clearly that if you bump off someone's employment and thereby cause loss of that continuing income, that is considered garmi. It may be that the status quo, we have to remember, as I stressed a bit earlier, employment is you could even call it a kinyan. You have not quite, but almost an ownership. You have a right within that person, that person will do the work, and the person has the right to do the work and get paid for it. And it's not so dissimilar to a kinyan you make on an object. You made the kinyan on the object, and you have to pay for the object. You've made a kinyan on an apartment in which you're going to stay for 3 weeks of the summer holidays. Once you've taken that 3-week kinyan, you may have to pay for that whole 3 weeks. You've acquired that right. So if you then cancel and you say, no, I'm taking that away from you. No, again, sorry, I'm confusing the picture a bit, because as I stressed, the employment hasn't started yet. But what you're doing is you're removing the possibility of that employment, and that's considered direct enough to be called garmi. Okay. That's halachic mechanism number one. Halachic mechanism number two, and this will be easier to understand given how we explain Rav Moshe's understanding of the whole concept of employment. As I say, you have when an employment is in place, it's a shibud both ways, and you can't simply terminate it by saying, I'd now dismiss you, don't come to work tomorrow. So basically, the employment is still in place against your will. I don't know how English law looks at it. English law may look at it that you have terminated the employment, but you shouldn't have, and therefore you should pay damages for having done that. I don't think, at least according to this avenue, at least according to this model, that's not how Holocho is looking at it. Holocho is looking at it is you had no right to terminate the employment, and therefore you couldn't terminate the employment. The employment continues, so your obligation to pay the worker should continue because he's your worker. That's mechanism number two. Mechanism number three is minhag. We said before, minhag is binding. Where something is common practice, you have to do it. Now here, you should ask me a question. Minhag has a certain limited koyach. In other words, the idea of minhag is not that you must do what the Romans do. Minhag is, as I explained earlier, since that's commonly done, that's the understanding that a person would naturally have. And therefore, if you enter into arrangement with someone which depends on implicit understanding, that would be the assumed implicit understanding. That's basically how minhag works. It's not simply that you've got to do what everyone else is doing, it's that it defines the understanding. So it only applies when a contract is in place. Now, when we're considering the possibility that you may have to pay someone for unfairly dismissing them, what is the concept behind that payment? What is that payment? So it may be that the secular law considers that payment as a tort, or at least akin to a tort. Like I mentioned a moment ago, it's damages, it's compensation. Now, I don't think minhag would allow you to collect compensation. It seems to me that if minhag works, what it's doing is it's making a certain clause be part of the employment, meaning that when you employ someone for, let's suppose indefinitely, for an extended period of time, built into that is I'm going to pay you £2,000 a month for this employment, right? Built into that implicitly, based on minhag Medina, is I undertake part of the terms of the employment are that should we encounter obstacles and I end up not being able to employ you further, I end up asking you to leave, nevertheless, I will continue to pay you for your work. I will pay you more money for your work. But my chiddush is, what I'm adding here is that if you regard payment for unfair dismissal as part of the schar pa'ula, as part of payment to the worker, then it's included in the original contract. And it seems to me only through that halachic mechanism could minhag work. Because if you wanted to be mechayev to the tort, then if halacha would support it, then halacha would anyway tell you to pay out, let's say, based on tina de garmi. And if halacha didn't support it, the minhag couldn't support, minhag or indeed tina de machusa, tina could not support what the halacha does not support. Have I explained that point well enough? That's I think a more that's a more involved point. But in any event, that is the third halachic mechanism. The fourth halachic mechanism is ha'anaka. The Torah says, I believe in Parshas Re'eh, Tanik Tanik Loi. If when an eved comes to the end of his tenure, then you should give him an allowance. I'm not sure how to translate the word hanik, but it means give him a package as he leaves. I think it says whatever Hashem blessed you with, give to him. Let him have a start in life. And the Sefer Chinuch says that based on that, it's appropriate if a worker, if a person sends away a worker, then by the same token, he should give him that support to start off. Now, this Sefer Chinuch, I'm not sure whether he's describing something which is a clear halacha or just an appropriate thing to do. If it is an appropriate thing to do, and if it's generally done, then once again it would become minhag. So it somewhat overlaps with the previous reason, but it is another further halachic source and further, to a certain extent, it's a further concept. So altogether, for unfair dismissal, you would conceivably have garmi. You would have the fact that you simply have to pay your worker, the employment continues. You would have minhag, and it overlaps with the previous category to a certain extent, and likewise you'd have a similarity to the case of ha'anaka. Now, the next point is, how much do you pay? How much? So here there's an interesting thing. It seems to be that the basic practice is the payment. The idea of the payment is to compensate the worker for his loss, for his or her loss, and that would basically depend on how long it's going to take to find another job. And I'm told, it's not something I've analyzed in real life. You may have seen cases in the real world. You may have a feel for it. It seems that often it takes 3 to 6 months to find another job. So if it seems like circumstances are difficult, go closer to 6 months. And it might be more, but apparently no tribunal would give more than a year. But again, without having done a careful field study, to me that seems about right. The person needs to search and go to interviews and make sure they're doing something suitable. It's going to take a few months to find the job. And the way the secular law looks at it is you've got to compensate for that loss. What would halacha say? Well, garmi would be, what did you lose? Garmi is cause of loss. Melacha, you pay, you would continue to pay as if the person was working because the employment should continue. So again, that's what they lost. And likewise, minhag, if we're saying that's what secular law does, the minhag would cover the loss. What would Hanukkah be? That's very unclear, but I guess if the idea of Hanukkah is that the person can start up again, what you need to start up is to continue your salary. So it seems to me like all arrows are pointing more or less in the same direction. But one interesting quirk I want to point out to you is that it may well be argued that strict halacha would not necessarily have mandated payment of the whole loss of earnings for the following reasons. There's the concept of pearl bottle. The Gemara's understanding is, and the concept presented is, let's go back to the case of the workers in the field. The workers are due to come to work tomorrow, but then you cancelled them. Now they were looking forward to coming and working and going home with £100 in their pocket. And now they haven't got the £100. Now suppose you would say to them, look here, suppose you would phone them and say, look, I want to cancel you. I appreciate it's unfair. Would you be happy for me to pay you £80 and stay at home? But anyway, worthwhile. Or let's suppose you would give them a choice. You'd say, look, I really fancy doing the work, but I'm leaving it up to you. Come and do the work and I'll give you £100, or stay at home and I'll give you 80. Now, many workers might well say, well, I'd rather stay at home and have 80. It's worthwhile to be mavata on a part of the money in order to be able to not have to work. That gives rise to a concept of pearl bottle. If you're responsible for having made someone lose work, then you have to pay. Why should you have to pay more than pearl bottle? Because they would have been quite happy to not do the work and stay at home. The problem is it's very hard to quantify pearl bottle. I mean, the Gemara talks about a certain case of people in Mechuzah who were quite strong people, and they were maybe what today we would call ADHD, very active people, people who like the challenge of manual labor. They keep going. They don't want to sit around doing nothing. So they gain nothing by sitting around doing nothing, and there'd be no deduction due to the principle of pearl bottle. However, in many cases, there would be a deduction due, and the Taz says, since it's so hard to quantify it, let's assume it's always going to be half, so you should always pay 50%. Now, it's a rough estimation, and somebody may not always go with that. They might use their judgment on a particular case, but that gives you a sketch of the concept of pearl bottle. But what's interesting is that the minhag that we have here in the UK for paying compensation for dismissal does not take that into account and expects the employer to pay the full amount. Now, you might deduct, it's an argument that certain things mitigated the losses. The worker was able to claim benefits. Then fair enough, that gets deducted. You wouldn't necessarily pay the full salary, but you would not make a deduction based on the concept of pearl bottle. Now,
I'm sorry, I may have to go in a minute because my family are waiting for me for dinner. Apologies.
Right. So I'll just simply say we have really finished the time. I don't know if I've got time to develop that thought. But it seems like the minhag is not to make a pearl bottle deduction. And if we're saying that one of the halachic mechanisms which makes you have to pay for unfair dismissal is the minhag, then probably we would go along with that, because any one of the reasons by itself and one of the mechanisms by itself would be sufficient. There is just very quickly, there is something called a Polke deduction in law, and that is what happens if you unfairly dismissed someone, but what you did was unfair by virtue of the procedure. You didn't follow proper procedure, and you're taken to a tribunal, and you argue that it's true that I did this in a bad way. I should not have dismissed like that. There has to be disciplinary procedure. There are other words for it. You have to follow a certain sequence, and in any event, you have to allow for a meeting and an appeal and so on. If you didn't do that, that itself makes the dismissal unfair. That itself makes you have to pay. But tribunals would make what's called a Polke deduction. What Polke doesn't mean anything. It's simply after a case precedent involving someone called Polke, and they would say, well, look, if we think there's a 10% chance that even had you followed the procedure properly, the dismissal would have gone ahead, then they choose to knock off 10%, 20%, or it could be 80% because they think, well, okay, the procedure made very, very little difference. And that's the final detail. So I had one more thing, but maybe we'll save that for another time so that we don't have to cut short and keep to our time. We mentioned basically Moshe, the Chadanish, UK law and American law, the idea of unfair dismissal, the chiyuv to pay based on garni, based on schar pa'ula, you've got to pay your worker based on minhag, based on hanaka. The basic amount would be to make up the loss, although in strict halacha it might be you would adjust that for the pleasure the worker had of not having to work, whereas minhag seems to be pay the full amount. Maybe halacha would support that because maybe in today's in many cases, with the economic stress that people have, people are not interested in the worry of unemployment, together with the reduction in income, which makes them have to struggle to live. So they do not take any pleasure in not working, and therefore pro bono wouldn't apply. It may be that that's the case. And finally, when there's a contributory responsibility, was it for another reason? When there's a likelihood that
breach of procedure.
When all there is breach of procedure, it's possible that one will get the whole amount. And based in may well follow that, but it would depend on whether the party that signs up for a procedure allowed the based in a certain amount of discretion, but that normally is the case. Okay.
Thank you very much.
Thank you, Scott.
A lot of research in that one.